in Samburu County. I am a beneficiary of ABSA scholarship program that has enabled me to pursue my degree in Bachelor of Real Estate in JKUAT. My mom is a primary school teacher. I would always see my mom going through this tough time, and she never gave up. So when I joined university, I thought of applying for HELB to ensure my smooth running of my education. I got a notification from HELB. They sent me a message and told me that I'm a potential beneficiary of ABSA Scholarship Fund. And they gave me the link to the website for application and the whole process. I never had to deal with the last minute struggle about rushing, clearing my fee balance, not sitting for examination because I have fee balances. I am in third year currently and I'm in my last semester. I would like to thank ABSA so much for this opportunity. Same way they stepped in my life and changed it, same way I do also one day want to just touch someone's life. Any opportunity presented to you, take advantage of it. It does not matter whether it's the 10th opportunity, the 9th, it doesn't matter. Just take advantage of it.
Welcome to the launch of ABSA Women in Business proposition. Thank you all for making time to be with us this morning. It promises to be an exciting day. And as a woman in business, I am excited as well to find out more and for you actually to find out more about what this proposition is all about.
There are numerous benefits and packages that come with the ABSA She account. But most importantly, as a force for good, we appreciate that Women in Business proposition is more of a mutual relationship to prosperity.
Through the ABSA She Business account, we are today committing to empower over 1 million women entrepreneurs across the country over the next 5 years with requisite financial and non-financial support to scale up and take their businesses to the next level.
Launching ABSA She account that calls upon the bank to continue creating equality in its workplace across the supply chain by ensuring that women's voice is heard while running an executive coaching program to get them ready for senior leadership position.
I think the whole role we are playing again as a She Business account is through access to the networking, the mentoring, the coaching will help you set up your systems.
The launch of the Women in Business proposition is very exciting because it gives the women the platform to have focused attention when it comes to access to finance. And they've gone a step ahead. They're not looking at access to finance only. They're looking at how do they capacity build the women in order for them to strengthen their businesses.
And I'm very happy with our partnership with ABSA. We continue to train women in different sectors, whether you're in agribusiness, whether you're in textile, whether you're in real estate, whether you're a teacher, wherever you are, we have training programs that you can plug in. And these training programs teach you how to start your business, to retain your business, and to grow your business. And as you grow your business, we then share with you the opportunities that you can plug in and own them. So right now, my excitement is that we've been given wings to fly. So we are ready to go.
So at SheTrades, we have developed what we call Gender Toolkit for Agricultural Value Chains, which is a guide to understand, to help not only farmers, but all cooperatives, producer organizations, private sector policymakers to really understand the gender inequalities within the agricultural value chains. And our goal is to assess producers, organizations, and companies' gender policies and business practices.
Thank you all so much for watching and for being part of this conversation. My name is Terian Chebet. It's been an absolute pleasure to be part of this conversation. Have a wonderful day.
Good morning. Welcome to this Wills and Succession Planning webinar brought to you by ABSA Premier Banking. My name is Nerea Okanga. I am legal counsel here at ABSA Bank, Kenya. Today, we want to talk to you about planning wills and your succession and planning of your wealth and your estate, and ensuring that your future generations, the people that your loved ones are cared for. Please remember there's a few housekeeping rules. Please mute your mic and make sure that your videos are off throughout the entire session. Today's session is being recorded and will be shared to you after via email. We have your email addresses. We will share that recording with you. Please feel free to engage with us in the chat box. Put all your comments and questions there, and we will address them after the speaker is finished. I'd like to now introduce you and welcome Simon Gishahi, who is head of our Premier Banking section at ABSA.
Thank you, Nerea. Thank you, Nerea. Thank you, customers, for joining us. Good morning. I'm really pleased to host you today. And this session today really marks one of the key things that we want to deliver for you as customers. Our promise as Premier is to ensure we create moments of relevance not just in banking, but also relevance in the opportunities and the things that we deliver to you. Today, we are partnering with Anjawala Khanna, one of the key leading law firms in Kenya. Anjawala Khanna is not just any legal partner. They've been in Kenya for over 50 years. We are working with their partner, Atik Anjawala, today. Atik has had extensive experience in the legal area, over 38 years of experience in this area, working not just in Kenya, but also in Dubai and the UK. That means that for our customers, we're not just talking about succession and will planning locally, but also for customers who have properties abroad. They're then able to contextualize and understand how they can actually go ahead and plan for their estates, for their families, as they protect their will, their plans. Now, for ABSA, for us, as I mentioned, as Premier Banking, our goal is not just to provide that transactional relationship, is to deepen the relationships with you. Our commitment is to offer you engagements that are more relevant to you, engagements that are going to give you value, and engagements that will help you think about how you build your wealth, how you grow that wealth, and finally, how you protect that wealth. At the end of the session, we are going to have a short survey. That survey is actually to check the relevance of this topic and also to pick any questions and any ideas you may have on other sessions that we need to hold just to give you more value. We thank you for your time today and look forward to an exciting engagement. Thank you very much.
I grew up as a lonely guy, just me and my grandmother. My mother passed on when I was just joining high school. This is the only memory I have of my mom. On the same week, my granddad, a father to that home, passed on. It was very difficult. I am Moses Ituma, a second-year student at the University of Kabianga, courtesy of the APSA Scholarship Fund from Kimilili constituency in Bungoma County. High school education was not quite easy because we are not financially stable. I had to speak to teachers so that they could allow me at school.
Mtoto huyu Moses ni mtoto wa mtoto yangu. Babu yake alikufa 1 week na mtoto mama yake anakufa. Mimi mwenyewe sikukuwa nachiweza, nilikuwa nimechanganyikiwa.
I went to the university. The Higher Education Loan Board linked with me with the APSA Scholarship Fund. I shared my story with them. They decided to fund me.
Ati mama, watu APSA hapo wamenichukua mimi. Hata nilikuwa karibu nikaanguka chini nikasema Moses usiniambie. Nikachanganyikiwa. Lakini nikaamuka nikashukuru Mungu sana.
It is beyond scholarship. APSA have given me a study laptop. They have given me upkeep money enough to support me at school and also support my grandmother. Now she's comfortable. APSA, you have wiped tears out of the face of a boy from an interior village. A boy who could not imagine of getting out of a mad house with his grandmother. Thank you, APSA.
My name is Amos Pogesho, a beneficiary of APSA Scholarship Program and currently working at APSA Bank Kenya under corporate investment banking. I was born and raised in West Pokot County. I'm a fifth born, and out of those children, I'm the only one who has gone through high school and joined campus. Growing up has not been easy for me. It has been tough because for me to complete my studies, it has forced me to move from one place to another. When my dad passed on, I dropped out of the nursery because there was no one walking me to school. After high school, I joined University of Nairobi, pursuing Bachelor of Economics and Statistics. The rough time came in second year. So after applying for help, someone called me in the morning around 8. You're one of our beneficiaries. They paid my school fees and provided me the laptop. They are here for me again. They have given me the opportunity to work with them, and I'm grateful. My education has helped me. That's why I'm here working. If I could not finish my university education, I think that I will not be here. Thank you so much, APSA Bank Kenya. Thank you so much.
Good morning again. Our speaker today is Mr. Atik Anjarwala, leading lawyer in Kenya and the UAE, personal friend of mine. Atik has been working in law in Kenya here for 36 years or so. He's very accomplished. And I'd like to just say, personally, I've known Atik for a very long time. Actually, all my life, part of his life, obviously. And when it comes to wills and succession planning, I would like to say that the personal connection that I have with Atik is that he helped me convince my own father, my late father, Dr. J.B.O. Okanga, to make a will. And not only did he convince him to make this will, but he helped him draft the will, and he's also an executor in the will. So I trust Atik with wills and succession planning, an area he's very familiar with. And I'm sure you all will be very educated and learn a lot from his webinar today. Thank you.
Good morning, ladies and gentlemen, and welcome to today's webinar. Norea, thank you very much for that very warm welcome. My thanks as well to APSA Bank for arranging this event, which is extremely topical, I guess, particularly in light of what is happening with COVID. Slide, please. So what I would like to do is just really give you some practical guidance on some of the key issues that surround the issue of estate and succession planning. What is very obvious is that families should consider making sure there's no uncertainty. I think nobody likes uncertainty, and not planning means that there will be uncertainty. So therefore, our advice is make sure that you record your wishes in a properly legally binding format, taking into account some of the attendant risks, legal risks, and other family requirements that obviously come about. What we've realized that every family is different. Every family has different aims and aspirations as regards their assets and their wealth planning, and therefore professional advice should be obtained to guide the family through these situations. Bear in mind as well that the laws and the procedures surrounding assets in Kenya will be different from the laws and procedures in other countries. So to the extent that you have international assets, bank accounts overseas or properties overseas, a lot of care must be taken to ensure that the planning around those, both from a legal perspective, but even critically a tax perspective, are taken into account. And I think the first major point which I would like to draw, and it's on the first slide, is the concept of intestacy. So that basically what that means in a Kenyan context is that if you haven't made a will, then you die intestate. That's a technical term. And what the law does, the Law of Succession Act, is that it gives a default position on intestacy. So if you haven't said in a properly binding will as to what happens to your assets, who are the executors, and all the matters that surround ownership of assets post-death, then the law will impose certain rules on you. And I think what you will realize once I turn to the next slide is that the default position of the law probably is not a satisfactory one for most families. The law, of course, has tried to find a middle ground, but I think once you see this slide, you'll probably appreciate that the default position is not ideal. So what happens if somebody passes and there is no will? So as I said, we're now talking about the intestacy position. The surviving spouse gets a life interest. What that practically means is that ownership of the assets of the spouse who has passed away does not vest in the surviving spouse. There's merely a life interest which ends upon death or remarriage in the case of a widow. Okay? So if you have a bank account, the interest on that bank account can be utilized, but the capital can't. If there's a home, then the rental income from the home can be utilized, but the surviving spouse can't sell the home, for example, because the interest is a life interest. And again, you know, I think a lot of people listening might feel that that may not be the ideal position for them. After the death of the surviving spouse, or in the case of remarriage, then the children will get an equal share absolutely. So if there are 4 children, then those 4 children will get the assets in equal shares, 25% each. Of course, if there's no spouse, then the next default position is that the children will get all the assets equally, as I've just explained. And then you can see, as you look at the slide, there's a waterfall of application of assets post-death. So if there's no spouse and no children, the mother and father, if alive, siblings or their children, and then half-brothers and so on and so forth. And again, I think if you think through this, you probably would find, in the case of most people, that these outcomes, which are imposed by law, you have no choice, are not ideal. So what you really should be doing is sitting down with your family, sitting down with your professional advisors, and working out as to the ownership and movement of assets post-death. I've just raised 2 further points on this slide, and for those customers who are Muslim, the Kenyan legal position is a little bit fluid. So although there is a requirement for Sharia application of assets on death, the general position of the courts is that if you make a non-Sharia will, that will can go through probate unless it's challenged. And so it's a little bit of a gray area. So for those customers who are Muslim, I think you need to be very careful about how you plan your estate. And I've covered foreign assets. So the position with foreign assets is actually quite complicated, and I'll touch on those aspects a little bit later in the webinar. But please keep this in mind, because just having a Kenyan will may not be sufficient to ensure that the foreign assets move in the way that you desire. And certainly there will be very substantial time delays for you to be able to pass ownership post-death. So, do you have a will? If the answer is yes, then I guess the first point to consider is it adequate? If you don't have a will, then the issues that I've raised on this slide are issues that you should certainly think about. So the first point is, who would be the executors of the will? So these are the people who would go to court to obtain probate, to legalize your will and ensure that your wishes are put into effect. Clearly, as you'll appreciate, executors should be people that you trust. So for example, if you have executors who are your siblings who live in the US, although you trust them, practically this might be quite hard because they've got to go to a notary public in the US, there'll be delays. So by and large, what we advise people is have people in Kenya, clearly people that you trust who would deal well with your family, and they would be the people who would normally go to court. Again, a couple of pointers, try and, if you have people who are 20 years older than you, or in the 80s, there's probably the risk that they will pass before you. So is it practical to have them as your executors, for example? If you have three, good to put in a small clause in the will that says the majority will prevail in case there's a disagreement. If you have young children, you must think about guardians. Clearly, the default position would be that the surviving spouse would be the guardian. But what if sadly two of you, your husband and wife, are going out for dinner, there's a car crash, and both of you pass? Okay? The important point regarding guardians is that they should really be people with whom your kids are going to be happy to stay with, who would be able to look after the interests of the children. And they don't have to be your executors. So often what we find is that I'm appointed, or my law firm is appointed as the executor, because we'll deal with the technical aspects of the will, but the guardians would be siblings or uncles or aunts and so on and so forth. So, and the will provide that they will liaise with the executors when it comes to payment of school fees and university fees and medical bills. Obviously, if you have young children, a lot of thinking has to go around, well, when do your children gain the assets? And there's often a big discussion, is it 18? Is it 21? Is it 25? When do you feel the children will be mature enough to be able to obtain their assets and deal with them responsibly? So there's no wastage. And again, that is something that should be talked about with your professional advisors. And well-drafted wills will have trust provisions so that these assets can be held for as long as is required until ownership can pass to the children. And these are actually very important provisions to put in, because if you have a house, who pays for the insurance? Who pays for maintenance? So on and so forth. So again, a well-drafted will should take these points into consideration. Powers of the executors and trustees, again, sit down and think about this carefully. And of course, if you have good professional advisors, they'll guide you. If you have very young children, for example, then the nature of the powers will vary. If you have a varied range of assets, for example, if you own a big commercial building, if you own a hotel, you need wide powers for the executors to be able to deal freely with these assets, which are income earning, and which are basically trading assets, because they require licenses, they require maintenance. So the nature of the powers that you have in the will are important. There is a default position under the Trustees Act, but our Trustees Act is very ancient. It's based on the 1925 UK Trustees Act. So a lot of the powers under the Trustees Act are not sufficient. So again, a well-drafted will should cater for these issues. Then the nature of the assets. Okay? So, depending upon your wealth, you're likely to have motor cars, you'll have jewelry, you'll have stocks and shares, maybe listed, some unlisted, you'll have cash in bank. So again, think about how you would want to deal with these assets, and different provisions might apply. Provisions that apply to a commercial building might be slightly different from a residential home, for example. So again, think about these issues, think how they will divest among your family, and where you have especially young children, please consider carefully how ownership would pass to the children and at what stage. I've touched upon a global will, and I've asked the question, is it jurisdiction specific? So for example, if you have foreign bank accounts, although by and large, a Kenyan will can be drafted so as to cover all your global assets, there are a lot of technicalities that come with enforcing that will in foreign jurisdictions, especially non-Commonwealth jurisdictions. So if you have real estate in Commonwealth jurisdictions, then the legal systems practically support each other. But if you have an asset, say in Dubai, which is not a Commonwealth country, or in a non-Commonwealth country, then applying your Kenyan will in the foreign country becomes extremely complex, and in some cases impossible. So where you have foreign assets, again, talk to your professional advisors and just think through, well, how do I deal with my foreign assets? Do I just cover them in my Kenyan will, or do I need to think about having country-specific wills? And you know, because I look after our Dubai office, and you know, we look after clients with assets globally, we work very closely with lawyers in other jurisdictions to ensure sometimes that the country-specific wills will work. I have a number of cases where we may have a will in India, a will in the UK, a special will in Dubai, and a will in Kenya. If you have assets in Tanzania and Uganda as well, there are nuances in the legal provisions that may not make it ideal for your Kenyan will to simply apply there. There are also lots of delays. So if you go through a probate process in Kenya, it's roughly 14 to 18 months. So it's only when that probate, when you get the final court documentation to deal with your Kenyan assets, can you now take it to a foreign jurisdiction and register your will there. And that will take another year or so. So if you think about it, it's almost 2.5 years before you can deal with your foreign assets. And in the meantime, everything is frozen. The good news in Kenya, at least so far, is that our friends from the Revenue Authority don't charge us any money when we die. It's about the only time that we don't pay anything to our friends at KRA. So currently we have no inheritance tax. There's no death duty in Kenya, which of course is good news because it's relatively cheap to die. But the same doesn't apply in other jurisdictions. So again, where you have foreign assets, think about whether there could be foreign taxes that apply. And certainly we sit with clients and work out how we can lawfully limit tax in foreign jurisdictions. This is a very important slide which I want to bring to your attention. And it's something that I think all families need to think about and be very honest and open about. Because what our law does, it gives rights to dependents and to the children of the deceased. And dependence is actually quite a technical term in our Law of Succession Act. And what I've done here is to set out for you, and I'm sure these slides will be shared with you so you'll have the information, individuals who are your dependents, but who you may not cover in your will for reasons that may be unique to your family, but who would have rights to disturb your estate. What do I mean by that? If somebody is your dependent and you do not cater for that dependent in your will, that person has a right to go to court to seek to vary the terms of your will and to ask the court to provide for them from your estate. Okay? And this is obviously quite a big risk if you do have a dependent. So if for whatever reason you don't include your wife in your will, she is your dependent. And she may be able to come and disturb your estate if you haven't catered for her. So it says wife or wives. Former wife or wives can also be a dependent. And this can be quite a large risk if you have had a divorce. Some people think that the separation is final at that stage, but that person could still be your dependent. Of course, they've got to show some dependency, but the point is there's that nascent risk that you need to think about. And then the children of the deceased, whether or not maintained by the deceased immediately prior to his death. Now, children would, obvious when you're talking that, it's your children, and if they're your biological children, obviously you want to cater for them. But what is the position of a child out of wedlock? The law has been moving quite a lot on this. The strict legal position seemed to be that for a male person, if he had a child outside wedlock, that child could be dispossessed and would not be a dependent. But the courts have said they don't agree with that legal position, and there's a couple of court judgments that have even requested that the law be formally amended on this. And essentially, what this means is that a child out of wedlock is now your dependent. And therefore, if you haven't catered for that child, then the mother of that child, for example, would move the court to disturb your will. Okay? And again, when I sit with clients, that's, we're a bit like a doctor, right? If your left leg is hurting, you shouldn't say my right leg is hurting. So the same thing is that we ask some very hard questions on these sort of issues. And obviously, we hope the clients will be honest with us. The point being that you need to plan around these arrangements, because what you don't want to happen is if you act like as an ostrich and don't raise these issues early enough, God forbid, in the event of death, your family will be faced with legal challenges. And that's the last time, or it's the last thing that you probably would want for your family. Then look at Class B. So it means the parents, step-parents, grandparents, grandchildren, stepchildren. And again, you can look through, it's quite a wide list actually. And of course, our social structures are such, especially in Kenya, where we, by virtue of our social requirements, we're helping wider family members. And we have a number of cases where, I had a case recently of a client, a very rich client based in Uganda, which has a similar provision in their law, who has a brother who has not been successful in life. And this client every month gives that brother some money so he can survive. That brother has now become his dependent. And when I was planning for this client, we had to find legal ways of ensuring that that brother didn't disturb the will of the client in the event that he passed, because he didn't really want to give his brother direct ownership to some of his assets. But we found legal mechanisms to deal with this. And then there's a slightly worrying proposed amendment to the law, which isn't part of the law yet. But what this does is to really widen the scope of a dependent. So to include persons who prove they were maintained by the deceased for a period of 2 years prior to the deceased's death. So just keep this in mind. It's not law yet, but if it does pass through, you will see that the Class A, the Class B, and the Class C have some relationship with the deceased, be it a blood relationship or be it through marriage. But the proposed amendment would widen this, where there has to be no family connection per se. So if you were generous in helping the child of a friend paying school fees, would that child become your dependent? Okay? And of course, the unfortunate position is that your kindness would leave you with a legal weakness. I just want to quickly touch on the question of a polygamous man's estate and the place of a partner in intestacy. So remember, intestacy is when you don't make a will. And the legal position is that African customary law doesn't have a direct role in succession matters after 1981. However, in the case of an intestacy, then this is when you don't have a will. A polygamous man's intestate estate is distributed amongst the houses in equal shares. So if there are 3 houses, and each house, say one house has 6, and one house has 10, and one house has 3, my math is very poor, but essentially each house will become a unit, and the estate will be divided equally among the units. So the bigger house, if you like, will have more units. Okay? So keep that in mind. The question of a partner is interesting, or by a partner I mean like a cohabitee as well. So again, the law is in a bit of a flux in this situation. Our laws are in a way quite traditional, based on philosophies of church or mosque, etc. And by and large, relationships outside the formal relationships are not recognized, unlike, say, lots of countries in Europe. But what we are finding is that the courts are challenging this because of the way that society is moving, even in a country like Kenya. And by and large, the position is that for a cohabitee, it is very difficult to claim rights of inheritance. However, where there are strong grounds to show cohabitation for a very large period of time, say 20 years or more, and the onus is on the cohabitee, the partner who survives, then there is some sense that the courts will be sympathetic to them. Okay? So again, if you are in a non-formal relationship, I guess the position is that if you expect to receive something in the event of the demise of your partner, for you to be able to prove that right is probably going to be quite difficult. So again, for people in informal personal relationships, you need to think through your legal position if the intention is for you to gain something from the estate of the partner that passes. Okay, what I've done in this next slide is, again, and hopefully you're finding this webinar to be quite practical and not technical, but inevitably there is some technicality that comes in, and I'm just going to throw some key points to you, just to keep them in the back of your mind, and especially where you may have assets that are outside Kenya. And in this case, your domicile, and domicile is a technical legal word which is separate from residence, separate from tax residence, and separate from citizenship, will guide the way that your foreign assets will vest if you haven't planned. Okay? So if you have a bank account in a foreign country, then, and if you haven't planned to make an estate, if you haven't planned through a will in that foreign country, or even planned through a Kenyan will, then the law of your domicile will apply. And if you basically have been born in Kenya and your entire life has been in Kenya, your domicile will be Kenya. And therefore, the earlier slide which showed what would happen in the case of intestacy, the spouse getting a life interest, the children getting an absolute interest after the spouse, that would apply to your foreign bank account. I know a lot of us have family outside, like in the US, for example. Again, I've just raised this point because there could be a lot of negative tax outcomes for people living in foreign countries if you haven't planned. And again, a little bit of planning, around this would save a lot of tax for foreign beneficiaries. Okay? I've just put religion there because, for example, if you have an apartment in Dubai, although the Sharia principles that apply, the Islamic principles of inheritance, are being liberalized substantially in the UAE, especially when it comes to real estate, you can't contract out of Sharia by and large. Okay? So if you have an apartment in Dubai, then that apartment will vest as per Islamic Sharia principles, unless you plan around this. I just want to quickly again touch on nature and status of assets. So there's some sort of quite basic stuff, but like clients will say to me, I own this property. And I say, well, give me the title deed. And the title deed will be in the name of a company. And what you actually own is the shares in that company. So you don't actually, if you think about it legally, you don't own the real estate. The company owns the real estate. You own the shares in the company that owns the real estate. And again, the treatment of that in terms of shares and how they're handled would be very different from the treatment of real estate itself. Same with movable property, shares, bank accounts, motor vehicles. Okay? And again, I've stressed this point earlier, the treatment of these movable assets in Kenya and in foreign countries will be quite different. Okay? So if you own shares in a company in Uganda, in a company in Tanzania, you need to think about this. Bank accounts, so if you have now, especially with foreign bank accounts, we have clients who have relationships with banks, for example, in Dubai. The important point here is that even though your relationship manager may be in Dubai, your bank account is probably, we use the term booked, is probably booked in Singapore or Geneva or London. And that means that the legal principles that will apply on your death are the legal principles in those countries where your bank account is actually booked. And again, on the last point under that heading, clients will say to me, yeah, I've got X amount of money in the bank account. And then when we ask them for details, it's actually their private company's bank account, not their bank account. Okay? And so again, the legal position changes because you don't own the cash in the bank. The cash in the bank is owned by the company. You own the shares in the company itself. And again, how you deal with those shares and how you own those shares would have an outcome which you don't intend. So if you own the shares with your partner jointly, and by partner I mean not necessarily your wife, but your business partner as well, because you haven't thought about it, the shares in that company may vest in your business partner on your death automatically, which means the business partner will own the company, which will own the bank account, and your family won't get anything. So again, think about the assets you have, the ownership. What is your classification of your asset? Is it actually real estate? Is it shares? Is the bank account in your own name? Where is the bank account? And I've sort of covered the last item on the slides, but I just thought it would be good to, now that I've given you some background, and I know this is a very quick run through, but hopefully you have now having some sense of some of the key challenges you need to think through. So sitting down, we just talked about the definition of a child. It's much wider than you think. It might not be your, for the want of a better expression, lawful child. Okay, do you have dependents? Okay, as I've said, the court has a very wide jurisdiction to amend your will to deal with dependents. Okay? And then clearly, and hopefully the point has been now made fairly clear, plan for your will and don't leave a situation of intestacy. I just think, if I may be slightly tough on this, it's irresponsible for you to do that because you leave your family with an unwanted burden in the event that you pass. I just want to quickly touch on trust structures. So, as some of you may be aware, Kenyan law is based on English common law, and as such, we have the ability to establish trusts. Some of you may be aware what this means, or what a trust is, but essentially, a trust is a contractual relationship between the person who established this trust, you as the owner of wealth, and your trustees. Yeah? And you can therefore establish a trust quite easily. Most of you will have heard of a charitable trust, right? I mean, that's fairly common. But we have a lot of clients who have now established private trusts. So these are really trusts that are designed to maintain wealth for their families. And what a trust basically does is that it moves the ownership of the assets from the owner, from you, to the trustee, who then holds the assets and all the economic benefits for the benefit of the beneficiary. Okay? And I'm sorry I'm being a bit technical, but that's the easiest way to explain it. Trusts have been in existence in the UK and Commonwealth countries for over 300 to 400 years, and the law is now very well developed around trusts. But they're actually fairly unique and very helpful tools to asset plan. Okay? Because if you think about it, if you move the ownership of your assets to a trust and therefore you don't own them, don't directly own them, then those assets can't be part of your estate. Okay? If they're not part of your estate when you die, they're not subject to a will, they're not subject to probate. And therefore, if the arrangements are properly done and legally effective, then some of the risks that we've talked about with children, with dependents, should fall away. Because a child and a dependent can only claim those assets which are yours. But if you move those assets into a trust, then they're not your assets. Okay? And what we are finding is, as Kenya gets more and more sophisticated, clients are looking for structures that can help them achieve these outcomes. There's also some, besides creditor protection, I mentioned, creditor could be a dependent, a creditor could be a child, a creditor could be any third party to whom you owe money. There are other benefits. It's confidential because the trust is held by the trustees for the family. It's not recorded anywhere. So the arrangements are totally private. Okay? It avoids forced heirship. So, if you are Muslim and you're concerned about Sharia, for example, if those assets have gone into trust, they're not your assets on death. So you can avoid the Sharia issues. And what we are now finding is that, and perhaps this is something, a further discussion that we can talk to ABSA about for families, but what we are finding is that, as wealth is developing in Kenya, and as people like me in my 60s now, I'm talking to a lot of clients who are my age mates who are saying, Atiq, listen, how do I pass the ownership of my company? I've worked for the last 40 years. I've built a very successful business. I have 4 children. How do I ensure that there's continuity of that wealth? How do I ensure there's capital preservation? How do I ensure that if I divide 25% of the shareholding to each child, they don't fight, right? What if one child gets divorced and the divorced child's spouse wants to take those shares away? So trusts are a very useful mechanism to try and protect wealth intergenerationally. And that's exactly what the English did, 400 years ago when they came up with the trust concept. I mean, there are many English families, there are public families in the sense that, we'll have heard about them, whose assets have perpetuated over 3, 4, 5, 6 generations using trusts. And the last point I just want to make on that, on that slide is that you can create trust in your lifetime. So you can move ownership to the trust during your lifetime. But what we're also doing is creating trust on death. Okay? And I'm not going to get too technical here, but essentially what you could say in your will, especially, for example, say you've got 2 big business assets and you want to ensure that your children don't fight over them. So the matrimonial home, the bank accounts, the motor cars, they can be divided fairly easily. So your home will go to your spouse. The money in the bank can be divided among your children and your spouse. The motor cars can be divided as you require. But the shares of your valuable companies that you work so hard to build would go into trust. They can go into trust for the benefit, of course, of your family. But this allows you now to perpetuate the ownership to your children and to your grandchildren. And some of the protections that I discussed in the previous slide can therefore kick in. Of course, I'm just running through this in a few minutes. There's a lot of sophistication around how you draft these documents and a lot of the legal requirements that go around it. But the point I want to make here is that these options are available. And what I found is that, a lot of clients who come to me didn't appreciate that these are actually options that they have. I'm just quickly touching upon this because I think it's important in the context, because you are clearly all successful business people. You're part of the ABSA sort of high net worth group. Okay? And this last point that I just want to really bring out to you without going into too much detail is that there are some very unique tax planning opportunities that one can use with the establishment of lifetime trusts. Okay? And our tax team at my law firm, work together with me for many high net worth clients to basically plan from a tax perspective the movement of their assets into the trust in a lifetime, but in a way that we can get many tax advantages, which including sort of rebasing for CGT. Now that we have CGT at 5%, and if we're going to follow our neighbors, CGT could become 30% quite quickly, because in Tanzania and Uganda, the CGT rate is 30%, and I guess there's going to be harmonization on taxes over some time, but the 5% could easily become 30%. So there are some fairly clever, unique tax planning opportunities that are available, where you can tax plan and you can succession plan at the same time. Okay, so I think I've tried to run through some quite difficult concepts with you. I hope that you have found this to be useful, and I'll pass over the mic to Nerea.
Thank you very much, Atiq. We do have a few questions for you, some clarifications. First of all, I would like to to first say on the last slide, CGT is capital gains tax, just in case we have the legal jargon. Not everybody will immediately connect CGT with capital gains tax. So let me just run through a few of the questions that we have here and some of the comments, questions for clarification. So a question we have from Susan. Susan would like to know and get clarity, are there certain types of property that legally cannot be included in a person's will according to state laws or the laws of the land? And which properties are these, and what are the laws that prohibit them from being included in someone's will?
So there's actually no restriction. There is, if you own an asset, be it a bank account, be it shares in a company, be it real estate, just think of all the different classes of assets that one can own. Everything is, if you own that legally, then you should be able to deal with that in your, in your will, including a debt. So say, for example, you've lent your friend, 5 million shillings, and there's a little loan agreement. If you think about it, that's your asset, right? Because that friend has to pay that money back to you. And God forbid you were to die before that repayment was made, your estate can claim that money from your friend. Again, if the loan agreement is properly drafted and your will covers all these assets. So, there's no asset per se that cannot be put into your will. The only thing I would say there is, of course, there's one or two points I would just raise is clearly if there is some sort of court order or some restriction that is to which your asset is subject. So if you've taken a mortgage from ABSA, of course that asset over your house, that asset will be part of your will, but will still be subject to the mortgage. It doesn't mean that if you pass, the mortgage disappears. You still have to pay ABSA back. Your family has to pay ABSA back. The one point that I did raise earlier that you just need to keep into account is there are assets that under Kenyan law can be, and I'm going to be slightly technical here, as joint tenants. And what that basically means is that, say, for example, I own my home with my wife as joint tenants. What that means is that if I die, that house won't go as part of my estate. It will move to my wife automatically. All I do is take the death, or not me, somebody will take the death certificate to the land registry, and they'll register the house in the name of my wife without going through probate. So where you own assets as joint tenants, and I touched upon this slightly with shares, because sometimes people don't think about this, but if you have a group of friends, you start a new business which is very successful, and you don't own the shares as Mr. A, Miss B, and Miss C, but you own them jointly, there could be a risk that in the event of your death, instead of your family getting the shares, they go to B and C. And therefore, ensuring that the legal ownership around these assets is clear is something that's very important.
Okay, I think Atiq, I'd like to follow up on Susan's question and ask, what about I think there's certain types of land, perhaps maybe community land or land that is in a trust that somebody might think that they have a right to include that land in their estate, but they do not.
Yeah. So I guess let me flip that the other way around. If that land the title to that land has to be in your name. Okay? If it's in a third party's name or it's held in trust, and I'm using this phrase loosely, sometimes we'll do stuff and say, whatever reason, it's not convenient for me to hold something now. And, I'll tell Nareya, just put this in your name for now. Yeah, because, I'm traveling overseas, Nareya, I bought this car, just put in your name, I can't go and sign the documents. Okay? Right. For example, and I pass. Okay. Now, of course, on the face of it, Nareya is the owner, whether we like it or not. Okay. Now, my family, if Nareya doesn't agree to give up that asset, my family may be able to show that actually it was always intended to be mine, but they would need significant paperwork to prove that it was mine and that she was holding it under some sort of informal arrangement because, I had traveled. So, clearly having sort of informal arrangements, and we see this a lot with families, right? Like, one brother will own the assets for all the other brothers in a new business because it's just expected that, that brother would not behave improperly. But sadly, not everybody is 100% honest all the time. So in that event, if the brother passed and his wife and children said, no, this is all my dad's, the other brothers would have to show good reason why a court should upset that ownership arrangement and say, no, actually it's for the family.
Okay, all right. Another question from one of our attendees is somebody named Innocent, says it's to do with the classes of beneficiaries under the law. So what is the position of widowers? I think, I don't know if it was understood that, what is the position for widows goes for widowers?
Yes, it does.
Or
it does.
Or is there?
No. I mean, there's no discrimination.
Okay.
There's no discrimination.
So there's no discrimination. Is it? Okay. And then we have a question here from Mr. Duncan Chege. Please clarify on children out of wedlock are entitled to a share or an equal share of a deceased estate. So would it be okay to give them, let's say a small percentage of the estate, and would that satisfy what the law requires, or are they required to an equal share as to the children of the marriage, let's say?
So it's actually a very, very good question. And regrettably, there's no easy answer to this, okay? So the court cases haven't said an equal share, but that you've got to provide for that child, okay? And that's a very complex discussion, okay? And provide, so I think what I advise would be is that at least plan for that child till the child is maybe 18 or 21. So what would be the school fees? What would be certain medical requirements and so on and so forth, so that until that child becomes an adult, okay? And again, as far as we are concerned at Anjarwala and Khanna, we'll often sit down with the client and find ways to achieve that outcome outside the main will. And there are mechanisms that we can deal with to ensure that we have an outcome where the main will or the risk of the main will being challenged is substantially reduced. So, for example, what we've done in the past is to establish a trust for that child. So, in the event that and cash can be put in into that trust either during your lifetime, or the will provide it that on death, X million shillings should go to this trust. And then the idea is that, if the will is challenged, we will go to court and say, well, he's already provided adequately for that. But actually, that child doesn't have to have a share of the main asset, which is the home or the family business, for example. Because clearly that's where there could be a lot of tension, because you would have essentially from the, if I may put it, official family's perspective, an outsider. So, this is where careful planning and thinking is required to try and de-risk the main estate.
So, okay, so let me just clarify. If the children are the children of the deceased, whether out of wedlock, in wedlock, whatever, they're grown. So the deceased dies, and as often happens, somebody appears from the woodwork, and it's a grown man or a grown woman in their 20s, 30s, and they say, I'm a child of this person. Can they claim?
So I think in that case, it's harder for them to claim, especially if they've not been a dependent. If they've never been, if the father has never paid for their school fees and they're standing on their own feet. But what I do in those circumstances is, well, because it is still cater for that situation. Because I think that's the safer position to take. Because I can see a court being sympathetic to that child. So again, regrettably, there is no clear legal guidance on this issue. The fact that that child has a potential claim is clear. The amount of that claim, however, in my view, if that person is, a successful person, has got a good job, then I think the financial claim he can make is probably quite limited. Okay. Because there has to be an element of dependency.
Right. Okay. Then there's another question here with regard to the, you spoke about units.
Yes.
It was interesting to me, where there's a polygamous situation, family situation, and you talked about that if there's 3 different households,
yes,
those are 3 different units. But is it that the households are the units, or it's the individuals in the households that are the
individuals in the household? So it's not. So if there are 3 households, you don't divide the 100 shillings into 33 shillings per household.
Right.
Okay. So one household has 6 people, one has 2, and one has 5. Excuse my mathematics, but you divide the 100 by the
yes,
exactly, yeah.
Lawyers are not,
we're
except
not
for when it comes to our fees. Lawyers are not very good at.
I think what you hear what I'm saying. So it's not that you divide, because there are 3 households, you divide by 3. You break it into each individual. So the spouse and each child.
Okay, those would be the units.
Exactly.
Those would make up the units.
Say they are 15.
Right. Yeah.
And you divide the 100 by 15.
Okay.
Okay. And each person is then entitled to his 1/15 share.
All right. Okay. Then we have here a question from Edna Chibole. She says, please repeat the definition of a trust. I don't know if you do you want help making it simpler?
No, so look, I'll try because and I apologize, because I'm trying to avoid legal jargon as much as I can, because I don't want to put all of you to sleep. But let me have another go. So, if you go back 400 or 500 years, and it's very interesting because I've read around the history around trusts, but what the English were grappling with is how do we perpetuate wealth? Okay? And you think about it, it's very smart, because what that does is actually it allows intergenerational movement of assets and ownership of assets through generations, and keeping it tight within one box as opposed to it being dispersed. Okay? And so what they came up with this concept of a trust, which is where the owner of an asset, so say, you are the owner of a very successful company, you would put your shares of that company into a trust. It's not a separate legal entity, by the way. People get this very wrong all the time. A trust is a contractual relationship between you and the trustee. So say for this example, you own the shares and Nareya and I are your trustees. The shares would move to Nareya and me in terms of legal ownership on that, as recorded in the company's registry in BRS. But it would say as trustees of the XYZ trust. And the trust document now is, these are very sophisticated documents, would set out the rights and the obligations. And this is developed over 400 years of law. So it's very well developed now. And it puts a lot of what lawyers call fiduciary obligations on the trustees. So most people, when I had the first discussion, said, what do you mean I'm going to move my ownership to you? Right? That's crazy. Yeah. And then we have to go through a narrative and explain to them that actually the ownership is not economic. The maximum you pay a trustee is a yearly fee. And the law puts a lot of very hard obligations on the trustee to act in the best interest of the beneficiaries. And I know there is, in the daily newspapers, there have been a couple of high-profile litigation around trusts. But again, I would venture to say that that's because these arrangements were not put together properly. I've seen a lot of messy trusts myself in Kenya. Okay, so the point is that when you put these arrangements together properly, they work. So you move the ownership of your assets to the trustees. The trustees hold them for the benefit of the beneficiaries, who are yourselves and your family members. And because that's a private arrangement, you can actually control your beneficiaries. Okay? So for example, we have cases where clients will say to us that my children will benefit, but I don't want the spouse of my children to benefit. Okay? So if my son or my daughter gets married and they go through a bitter divorce, that person should not be able to claim anything against those assets, right? And this is a very interesting mechanism where you can legally ensure that the risks of those claims being made are eliminated. Because if you think about it, they don't own those assets. Okay? If I'm getting divorced, my wife can claim assets by and large that I own. And of course, I'm now being a little bit simplistic because when I'm not dealing with sort of a lot of hard legal issues, but that's the principle. And if I don't own something, it's not part of my estate when I die. And when it comes to creditors, like in a divorce, they should not have the right to really obtain those assets because they don't belong to me. So I hope you've got some sense of the definition, but happy to discuss that separately outside this forum if required.
Okay. We actually have quite a few more questions here. Question from Susan again. In your experience, can one contest a will based on it not being a fair split, based on the law of matrimonial property, etc.? Can somebody come and say this is not? It's not, so the out of wedlock child, or just a child, or maybe one of the wives or former wives, dependents, come and say this is not a fair split.
No, so I think so the starting position is that in Kenya we have freedom of testamentary disposition, which basically means we can give our assets to whoever we want and whatever proportions we want. The overlay is the dependency rule. Okay, so if you have grown-up children who are successful, okay, and for whatever reason, we have this quite often sometimes, you will have 3 children and say one child is challenged, and you want to obviously make sure that that challenged child will be catered for in case you die. Yeah, and that might mean that the challenged child within the will create a trust for the benefit of the challenged child. So in case the other siblings don't look after that child, at least if you passed, that child will not have financial constraints in terms of going to hospital or being at a home, or whatever may apply. So the general principle is that you have the right to divide your assets the way you do, subject to the overlay of dependency. Yeah, like I'm a child out of wedlock and you didn't cater for me, I have a right to come in.
Yes.
Right. I'm your lawful child, okay, but in the will you only leave me 5 shillings. Okay, how am my school fees going to be paid, and so on and so forth. Okay, but otherwise you have freedom, and put it this way: if you are fighting with your son or daughter, okay, and they're not your dependent, and that's why these definitions and the way this interlinks is very important. But they're not your dependent. There is no obligation to give that child with whom you have a quarrel anything.
Okay,
I hope that answers the question.
It does, and I think it answers another question here, which is followed by a comment. One of our attendees has actually said, "How does one handle succession for children with special needs?" And I think you just touched on that. And it says there is a case in Eldama Ravine currently where a child with special needs is at risk of starving to death, courtesy of her brothers, so that they can inherit the land that was left to her by her father. Yeah. So you've touched on that very well.
And again, I think the point is that you need to have documentation that is well drafted, legally sound, and if you have a health issue, you have a bad knee, you don't go to a gynecologist, right? you go to orthopedic, you go to an orthopedic. So the same thing in law, and this is what I tell a lot of clients is that, you know, I mean, I don't do court work. I'm not a litigator. So again, you know, trying to identify your professional advisors who have deep knowledge in these areas, because they are sophisticated, yeah, and the overlay of all the points that I've raised, and tax, by the way, because we keep on forgetting that, is very vital. Because ultimately, you know, for me is how do I preserve the client's capital? How do I preserve their wealth? And how can we allow for the intergenerational movement of these assets between the family members?
Right. Okay. Few more questions. If you have from one of our attendees, if you have a will and you have your company, but it's not included in the will, but you said that a company is a separate legal entity, so it's the shares in the company that you would include in your will, right? But you have a will shareholder agreement to take care of major shares of the founder to a trustee separately. How do the two relate? Will the will and the shareholders agreement? So how does it? Yes.
I understand the point.
Yeah.
I understand the point. Yeah. So again, any agreement that you signed in your lifetime, subject to one or two small legal points, but I won't bore you with them, will bind you when you die, or not bind you, will bind your estate when you die. Okay. So, for example, you have a guarantee with ABSA. Okay? The fact that you die doesn't mean the guarantee disappears. I talked about the mortgage the same way. That's also an legal agreement. Same with the shareholders agreement. If you've entered into a shareholders agreement, that shareholders agreement would bind your estate. So the rights and obligations of the shareholders agreement will perpetuate post your death, and the executors of your will, okay, will be bound by those terms, as will your family members. So say you hold 10% of a company and you've signed a shareholders agreement with the remaining 90%, and there are various rights to do with buying of new shares, selling of shares, raising more capital, so on and so forth. What would happen is that in the event you passed, essentially your estate would fall into your shoes.
Right.
Yeah, and they would be bound by the same terms. And of course, what this means is that, you know, when I work with clients on these aspects, and in a way, it's a very good point, because what happens sometimes is that you may be very close to the 90% shareholders, but your family may not. Okay? And then we have a discussion around, you know, should that at that stage, for example, should there be a right of exit? Okay, so or would your family want to continue in the business on the same terms as you do? Okay, is the 90%, you know, what are the 90% shareholders? They just hate your spouse. Okay, it happens sometimes, right? And that person now becomes a 10% owner of the business. So these are other things that we would normally talk to clients about, but the legal principle is that the estate would step into your shoes.
I'd like to take the liberty and combine some of the questions here. So one of the questions, some of the questions I'll combine is with regard to trusts vis-a-vis a will. Where would you recommend, in what circumstances would you recommend creating a trust rather than writing a will? And where is a will better than a trust? And how does that apply globally? So, you know, you spoke about assets in different jurisdictions. If you have assets in the UK, in Dubai, in the US, in Kenya, in Uganda, would it be better? Would you recommend creating a trust in each of those jurisdictions? Would a global trust do? Or would you recommend creating a will in each of those jurisdictions?
Yeah, thank you. So it's actually it's a very complex question, but I'll try my best to just run through some of the concepts. So, you know, clearly, you know, trusts are, as I said, very sophisticated and very useful instruments, but they, you know, it also qualifies, I think, where there is a certain amount of wealth. because it comes with expense and it comes with arrangements that require yearly fees to be paid to the trustee and so on and so forth. So, if you have a home in Nairobi, a couple of cars, and some cash in bank, okay, my sense is that having a trust during your lifetime probably doesn't make sense, and that you just would then have a will, unless of course you have a challenged child, for example. Okay, and what we can do for you then is we can create what is known as a will trust. Okay? So what would happen is that in the will itself, you establish a simple trust, and one of the terms of that trust would be that in the event I pass, the house goes to my wife, the car goes to X, Y, and Z, and 80% of my cash goes to the trust for the benefit of my challenged child. And then the trustees will, keep that money with ABSA, try and get the best rate of return through ABSA in terms of the investments, and ABSA would guide them, for example, on where to put that money. Should it just be deposit account or something more sophisticated with the trustees? And I'm a trustee of many trusts, and that's exactly what I do with liquid assets. We try and get the best return for the beneficiaries, yeah? And then the balance of the cash will go to the children who are not. So it's quite flexible. But if you have large companies and you own big commercial real estate in Nairobi, for example, then creating a trust in your lifetime is something that I would at least recommend you think about. Bearing in mind as well that there are certain very unique tax advantages that you could rely on to combine both some interesting tax planning and your succession planning through a trust. So what am I saying? I think look at your assets, okay? Look at their value, right? Look at what, if you have one son and your wife, or, if the wife is the bread earner, the husband and the son, why would you make a complicated trust? No point. Just give it to them and they'll divide the assets between themselves. And it's quite straightforward then, especially if there's no quarrel between the spouse and the child. But where you have 12 children and 2 homes and a big business and then some of the stuff that you read in the newspaper here will presents that. Some of the families that are disputing in court now tend to be these large families, right? So that's where some of these more sophisticated arrangements would make sense. Touching on the global picture, I really can't give you a clear answer, I'm afraid, because it's really jurisdiction dependent. Okay? It could be religion dependent, because if you're Muslim, then the sort of Sharia application is very different globally. Okay? So, but I'm doing one matter currently, but I think I mentioned earlier. For that client, we have a will in India, a will in Kenya, a will in the UK, and is actually non-Muslim, a will in Dubai. So we're ending up with 4 wills. Okay, and you have to draft them very intelligently, because they all have to stand on their own. Because if you don't draft them carefully, one will could sort of bounce the other out by wording, right? So you could draft this extremely carefully so they are siloed. So the Indian will is just India, the Dubai will is just Dubai. But the point is that we've got a global understanding of the client. We understand the legal concepts in each jurisdiction, and then we're able to put together these 4 wills. So if unfortunately death comes, hopefully it should be relatively smooth sailing for that client.
Well, this brings into question, the costs of drawing up a will and administering that will vis-a-vis the costs of a trust. The trustees need to be paid, the fees that the trust needs to pay out and needs to be paid in. So again, in balancing that, what would you what would you recommend that people take into consideration?
Yeah, we have a very open discussion with clients. As I said earlier, that if your estate is uncomplicated. First of all, if your estate is uncomplicated, what I mean by that, you may be extremely wealthy, but if you have no dependents, there is no second family. It's a husband, a wife, and a son and a daughter, right? And the family get on really well and there's no real issue, and your assets are substantially liquid cash in a couple of homes, you don't need a trust, because you'll say, if I die, all the properties go to my wife, I'll divide the cash as follows, and the wife's will say, so that's another point I would draw out, that often it's sensible to have mirror wills. Yeah, because what happens is that, case of the car crash or the wife passing as well, then she will say that, if the husband dies first, we tend to find, it's a bit of a joke, right, that the men buy before the women, but if the wife inherits the property, then she would then simply say in that will that when I die, these 4 homes are divided among my kids, and home A goes to son, B goes to daughter, and so on and so forth. There might be some balancing around value, and normally you can do that with cash. Yeah, so you would say, okay, if the son says, listen, I'm living here with my wife in this house, it's a big house in Muthaiga, the other properties are somewhere else, you can give the daughter some cash to balance it out. And again, that's just an open, frank discussion with the clients that you would want to have. And the point I'm making is that even if you are very, extremely wealthy, but your family and your assets are not complicated, there would be no need for a trust. Why would you overlay it with complexity and cost? But the flip side is, if you are relatively wealthy and you have a complicated estate, then trust can be very helpful.
Here's a question that I don't think we can exhaust here, but that I'm sure there's in the back of everyone's mind when it comes to creating a trust with a trustee is, what about a rogue trustee? There's always that fear. You trust somebody to administer this trust, but they turn rogue and don't do, or they go by the letter of the trust or what says in the trust, but they find loopholes. And what can the beneficiary do about that?
So look, it's a very good question. And for clients of mine who don't know me or haven't dealt with our firm for a long time, that's probably the first question they'll ask you. So clearly a well-drafted document. 2, please note that the law puts a lot of obligations on a trustee, right? These, as I discussed earlier, fiduciary obligation, this under the Trustee Act and just common law. So, unless the trustee has a death wish and wishes and doesn't want to be sort of known in society again, he or she will be very foolish to do something silly. Having said all of that, there's some quite simple arrangements you can put into place, like a very clear right to fire the trustee. And that's what I do. So when I'm a trustee, and I'm very frank and open with my clients, I make very plain to them that we may get on extremely well today, but say God forbid tomorrow we have a misunderstanding. The way I'm structured as a human being, I don't want you to feel that I'm your grandfather now, because I'm your trustee. So you just have a right in the trust deed to fire the trustee and appoint another trustee. And when it coming to the trustees as well, keep in mind, because we've had this happen quite a few times, unfortunately, and we've had to now then take quite expensive and complicated steps to unwind trusts. But because under our constitution, non-Kenyans cannot own freehold land and cannot hold land leasehold which is more than 99 years, if you by default have your cousin in the US who's a US citizen as a trustee, you may lose your freehold. Yeah. So the deeds that we prepare have lots of provisions around, if you fire a trustee, the new trustee that must come in must be Kenyan citizens, and because we want to make sure that your underlying assets value is not affected. Yeah. So there's a lot of technicality around all this stuff, but it's it's in the right circumstances, and as I said, if your family assets and your family structure require a trust, then they can be very useful instruments.
Okay. A few other I think, simple questions. One is, do assets in a will, in the case of a will, do assets have to initially be transferred to the executor's name on death and then to the beneficiaries? Is that the process of how it happens?
That's how it works legally. And then, of course, the executors become essentially the owners, and then they transfer to the beneficiaries. And so if it's a piece of land, the land would go to the executors, and then they would transfer it to, the 4 children, for example. If it's a plot of land and the 4 children are the beneficiaries, then the executors would do the transfer to the beneficiaries.
And I think one attendee is asking a question here, if they don't mind how I rephrase the question. But okay, what they have asked is, in the case of a joint tenancy of property with your spouse, can it be designed to transfer to a trust? So I think that they're trying to say, because we know that with a joint tenancy, there's the doctrine of survivorship, which, it automatically goes to the other tenant. But then how, I suppose the question is, how, if you're jointly owning a property, can you ensure that perhaps your portion goes into a trust rather than to the other tenant? And the only thing I can think of is, unless you hold the property as tenants in common. Yeah, so
what you could do is, say for example, you have a challenged child, okay, and your main asset is your home, and you clearly don't want to transfer that in the event of both the spouses passing away to the challenged child, because the challenged child will not be able to manage that asset, right? So so the way that your wills, I would draft your wills, is to say as follows: that if I am the sole owner of property XYZ, and both wills will have the same wording in it. And if you think about it, because of the joint ownership principle, if your will says, if I am the sole owner of property XYZ, ipso facto, it means the other spouse has died. Yeah? Because if I'm the sole owner, that means I have now become the sole owner.
Yes.
Right? So again, put the situation that husband and wife, they both have similar wills. Husband dies, wife becomes the sole owner of that property, and she dies. So the clause in her will say, if I am the sole owner of property XYZ, and then the will go on to say that I'm creating a trust for the benefit of my challenged child.
Right.
So that's, I think, the legal route that I would take to put it into trust.
But you can't put a joint tenancy.
It's a joint tenancy.
Yes,
yeah,
it's a joint.
So you can't.
Yeah. I think a few more questions before. Someone here wants to know what. So the spouse died intestate, and they had bought some land on which the siblings have gone to settle with their family. So they want to know, it's their late spouse's land. They want to know what right do their children have to that land that was owned by their late spouse. And they died intestate. So at this point, my husband dies intestate, and the brothers of my husband come and settle on that land that he bought with their children. And I have children with my husband, but we've never settled on that land. But now it's coming to.
Yeah. So assuming that, on the assumption that the brother and sister who are living on the land I don't have what lawyers call adverse possession. Okay, so adverse possession is where if I have a piece of land and Nerea comes and stays on that piece of land with my consent for more than 12 years, she can own that land. Okay, it's a concept of what we call adverse possession. And I'm just, again, this is just very high level, but I'm just putting it out there. But it doesn't sound like that's the case here. Okay, So what I would do is that I think you need to go to get a probate so that you can prove that you are now the owner of that land, i.e. the spouse. Yeah. So they go to court because that spouse would be entitled. She would be the first person entitled to get letters of what we call letters of administration, the probate. And as long as the husband owned that land, title of that land would move to her. She'd have a life. You know, when I gave the waterfall, the spouse gets the life interest, right? So the spouse and her children would become basically seen as the owners of that property. And obviously, as owners now, they can take action against the other family. It's a little bit long drawn out, but I'm afraid that's sounds complicated.
And finally, I think this will be the last question before, there's so many. What happens to your will or the trust if you and the trustee both, and the executors, you all pass away, unfortunately. Everyone dies, is gone.
So,
what then happens?
So what happens is, for example, never have one trustee, basically. Yeah, for example, at our firm, we have a corporate trustee, which you can have. It's, so before ABSA, the old Barclays days in the 70s, Barclays Bank used to have a trustee company. Okay, they closed that business down. Okay, and of course, the advantage with that is the company doesn't die. So you always have a trustee. But where you have natural persons as trustees, my advice always have minimum of 2, or ideally 3, right? So that if A passes, B and C will have the right to appoint a new trustee. Right. Okay, and so they have a perpetuation. But if in that scenario, basically the family would have to go to court. There's no other choice. And under the Trustee Act, the court would appoint fresh trustees.
Right.
So it's not the end of the world, yeah. But unfortunately, it would obviously be expensive and time consuming.
Okay. My biggest takeaway on this, I don't know about you, I've learned a lot, but one of my biggest takeaways on this is that if you are, as I'm sure a lot of our attendees here, if you have assets in several different jurisdictions, please consider making arrangements in those various jurisdictions. Please consider making arrangements for your assets, how they will be managed on the unfortunate time of your demise. I think for me, that's my biggest takeaway. But there is so much more, and we want to thank Atiq for this very enlightening session. And Atiq, if you have any final concluding words?
No, for me, it's just to say thank you for being extremely patient. I know it's a complicated area, but I hope you found it useful and productive. Wish you all the very best. Thank you.
Thank you. Again, Atiq is Senior Partner at Anjarwalla & Khanna, part of the Africa Legal Network, which is all over the world, pretty much at this point, but very prominent here in Africa. And Anjarwalla & Khanna is the law firm here in Kenya. So we'd like to appreciate him and appreciate you for joining us today. We'd like to hand over to Simon Gashahi at this point.
Thank you, Nerea.
Simon is just getting pretty. We'll have to wait. There is a survey that will be coming up. If you will take the time, please, to complete that survey and let us know, let us have your feedback on how this went, on what other sessions you may wish to have in the future. And also, of course, if you would like Atiq to come back and speak some more on particular topics. I know there was a lot of interest on trust. So if we could have that, if you could let us know on the survey. All right.
Thank you, Nerea, and thank you so much, dear customers, for joining us this morning. We don't take it for granted that you took time off your calendars just to be with us and get this value that you are looking for on wills and succession planning. I really want to thank Nerea for hosting us. She's been a wonderful host. I want to thank Atik. Atik, thank you so much. We'll be doing more with Anjawala Kana. I think it's pretty important that we get your feedback, how relevant this session was, what other sessions you think we need to pick up. There are people who are interested in tax, other legal matters, properties, wealth, etc. So give us that feedback, and you'll be seeing more sessions like this from ourselves. Now, there are a lot of questions we've seen, over 30 questions. We may not have answered all of them due to time, but what we're going to do, we're going to ensure that you get the connection to Atik. Number one, we'll send the presentation to you. I've seen a lot of questions coming in about the presentation. The second thing we're going to do is send you a recording of what the session that we just had, and you're going to do that through email, so expect that later today or Monday at the latest. Then lastly, we're going to ask Atik to really help follow up on some of those questions that came in the periphery, just so that then you're able to get your responses as soon as possible. Mine is to thank you on behalf of Absa Premier Banking, to really thank you for your stewardship, for helping us, for being with us as Absa, and ask you to really wish you a good weekend. Thank you very much and have a good day. Thank you.
Ambaye si mlemavu ni tofauti.
Nilikuwa mimi ni mtu mzima kwanza, alafu sasa nikaingia kwa ulemavu nikiwa naona na macho yangu. Kwanza ilikuwa ni ngumu, sasa ikawa kwangu sina raha.
Sasa nikaanza kuona watu tofauti tofauti na ulemavu tofauti tofauti, na sasa nikajikubali.
Tunatengeza products ambao hata uwezi amini ukiambiwa hii imetolewa mali fulani ya walemavu.
Bombolulu started as a farming place. It has had many faces. We have rehabilitation places like the clinic where we do rehabilitation, and there are so many people that Bombolulu has been able to help.
Kuna watu wanaona kuwa mlemavu ni mtu wa kusaidiwa peke yake. Wewe unategemea misaada, lakini hapana, si hivyo. Kiini hasa cha Bombolulu workshop ni kuona ya kuwa hata walemavu ni watu wanaweza kufanya kazi na kuishi wakijitegemea na kuwa na familia zao.
Kiwanda hiki tunatengeneza vifaa kwa bidhaa vyetu kwa mikono yetu, na tunategemea watalii watoke nchi za ng'ambo, wengine local tourists waje wanunue.
Bombolulu was on a trajectory high because we had up to 8 customers from Europe.
Kama ushazoea, mimi nyumbani kwangu nala pengine mfuko mmoja au mifuko miwili, na najua nimejipanga mwisho wa mwezi nitapata mshahara, na weka stoki yangu ya chakula ambayo itanimalizia mwezi.
When COVID happened, there were so few products that could be moved in the market. So we started making PPEs. We went to KEBS and we got certification, and we started doing for the few people who were around. Absa saw the need of helping us.
This place was like almost to be closed down because we were about like just 4 to 3 people, the orders we've been getting from the hotels. But now with this order from Absa, we had to call in the whole group so that all our machines now are working.
Absa kwanza nashukuru kwa sababu itafanya ule mtoto ambaye ameregeshwa nyumbani kidogo atarudi shule kupitia Absa.
My vision to that is we would like to have a bigger collaboration with Absa. The CSR activities they do other places, they can come in and help us get more models for the wheelchairs. The financial partnership, which is very important for any production. The financial partnership is enormous. Thank you, Absa.
Asante Absa.
Asante Absa.
Asante sana Absa.
you.